Welcome to the Freedom Property Podcast, the modern real estate brand empowering excellence. What is going on, ladies and gentlemen? We are back in the studio. Today we have Rebecca Petroff from Sunstate Conveyancing. How are you?
Good, thank you. Thank you so much for having me. Very excited.
Absolutely. You do heaps of podcasts, don't you?
No, not at all. This is my first one.
We were just speaking about that. You said, you were excited to come on the show and have a chat and let the agents know what you do in the conveyancing world.
Yeah, definitely. It's really exciting. So I think that there's so much that is behind the scenes when it comes to conveyancing and everything like that, that a lot of the agents, we can be, so helpful and a tool that you can use on a daily basis. And I think so many people are missing out on that opportunity.
Yeah, absolutely. Yeah, where's your office?
So we've got a HQ based in Lutwyche. Yeah. However, we have quite a number of virtual offices because we work around where the team member actually lives. So we've got offices around Gold Coast, Thornlands. We've got one in Bundaberg, Mount Isa and Sunny Coast. So we've got conveyancers actually there able to help, ready to go when you're ready.
So good. Nice. So, let's talk about this conveyancing world right now. And this is important because agents, if you get your contracts wrong, you may not get paid.
100% correct. And it's the last thing we ever want to do, especially, when the agents have worked so hard to obviously get the deal together and that sort of thing, and then they can lose thousands of dollars because of one silly error. Yep. So when it comes to errors at the moment, we're seeing a few things when it comes to conflict of interest. That's a real huge one. So that's where a party lets the other side know information that they shouldn't have known previously. So, for example, we had a case where we were acting for the buyer on this side. So the conveyancers always have to act in their client's best interest, not both parties. So that's where it sort of gets a little bit tricky as well. So we had a buyer and we got told that the seller was going to be overseas and they weren't going to go back to the property before settlement or anything like that. This buyer rocked up to the pre-settlement inspection. There was quite a number of things wrong with the property. There was items left and that sort of thing. And unfortunately, we were told by the agent previously that the owner was going to be overseas and they couldn't fix it and that sort of thing. So the buyer then weighed up their options and they were able to ask for quite a substantial reduction in the price.
Yeah.
Right on settlement day.
Yeah.
And then what actually happened was the seller then got upset and actually took the agent to QCAT where they lost their commission and actually claimed damages as well.
Oh, wow.
Yeah. So it's pretty, one little mistake, you wouldn't think that, hey, seller's away overseas, telling the buyer that could cause that sort of issue.
Okay. So as the agent, you really need permission to tell either party really anything, don't you?
Correct. And if you're ever unsure, if you're talking about the seller, always go directly to the seller's solicitor. And if you're talking about the buyer, go to the buyer's solicitor. And that way you're always sort of safe. And then the solicitors can also then decide what they can pass on to the other side. And that keeps you safe as well.
Okay. So what are things that agents are allowed to say and not allowed to say?
They're allowed to say things like, I believe there is a mutual agreement between both parties. You can definitely say something like that. Can you please confirm? And you can send that to both solicitors and everything like that. Yep. So you can call the other side and say, I believe there's a mutual agreement. Anything that they've come to you and actually both parties have agreed to, you can say that sort of thing. But if you're ever in doubt, just call someone and say, can I ask this question? Can I let the other side know this?
Yeah, nice. When you're selling a property as an agent, and let's just say it's a deceased estate, or let's say there's something that's happened at the property that as an agent, and then a buyer asks you a question about this thing.
Yep.
What's the response there?
So I would definitely be checking those things before it goes to contract. If you know it's a deceased or estate, prior to obviously it going to contract, I'd be checking with the seller and the seller's solicitors. First of all, if it's joint tenants or tenants in common, if it's a deceased estate or if someone has died in the property previously due to suicide or murder or something like that, I would be finding out from the seller's solicitors if you legally need to disclose it. Same with if it's been a drug dealer's house and there's been criminal raids and that sort of thing. So you always need to disclose that. So if you find that information out, I'd be going directly to the seller's solicitor and saying, hey, is this something we need to disclose? Can you write me a condition right now to put that into the contract? If they say, yes, it needs to be disclosed and we're going to put that into the contract, that is something that you can talk to the buyer and tell them about.
Okay. Yeah, wow. So it's not like something you have to tell.
So like when it comes to it, it's anything that can be used as basically used against the other party. So for example, if you were selling a property and you said, oh, the sellers need to sell this today because they're going to go bankrupt, they'll take $100,000 less than, what's on as the purchase price or something like that, that's actually causing damage to the sellers because then you're going to have someone come in at a very low offer and that sort of thing. So they can actually go, well, you shouldn't have provided that information to the buyers and it's actually caused me damage and cost me money.
Yeah. Okay, cool. Yeah, nice. Let's say the property has had previous termite damage, all right? And you're at the listing presentation as the agent and the seller's like, we've had previous termite damage at the property, and then a buyer at the open home says to you, do you know anything wrong with this property? What would be the response there?
Unless you're a qualified building and pest inspector, I would be saying it is up to you to do your due diligence. Unfortunately, I can only tell you about the house. I can tell you about the features and everything like that. When it comes to what's under the surface, I'm not a registered building and pest inspector, and we would encourage you to do your own searches. So get your inspector out there. If you're worried about it, get your engineers out and everything like that. Because at the end of the day, if you don't have those qualifications, you don't want to be providing advice on that either, because that could come back at a risk of, professional indemnity and that sort of thing under you.
Cool. I like this game. All right, let's keep playing.
So many situations and there's so many different answers and you're like, I'm trying to do general advice as well.
Yeah, well, this is general advice, but I think, that's what we need right now. Yeah. But
I think the easiest thing is if you ever get in a tricky situation, you're not sure what you can tell, pick up the phone and ring one of us, even at Sunstate Conveyancing, say, look, guys, I just need some general advice, not in regards to a specific situation, but I just need some advice for me. What can I do?
Yeah.
We're all pretty chill and relaxed and we're always happy to have a chat.
Yeah, absolutely. Let's say you've got a property and downstairs has got a bedroom, but it's not legal height, and you're at the prezzo and they're like, we'd like to market this as the 4th bedroom, but it's not legal height. What do you do then?
So this is we are actually getting this one up a little bit at the moment. So we've had a few situations in relation to this. So it is the agent's responsibility under the Property Occupations Act to make sure that you are doing the best due diligence you can as well. And you can't fraudulently, advertise something if you know it's not legal height or something like that, because then the buyers can have a claim against you for non-disclosure and misrepresentation. But however, if it is what your sellers are, explaining and forcing you to sort of advertise as well, I'd be very careful about what you're putting into your advertisement, but I'd also be getting all of these instructions very clearly written from your seller and signed to say that is what they're telling you is correct.
Awesome. Nice. Okay. Here we go again. Let's say you're at the presentation and the seller says to you, listen, we didn't get the approval for the outdoor entertaining area, but we'll be all right, won't we? Like we can just mark it as is.
So with that, because I would be advertising them I would tell them from a legal point of view. So there's a few different points of hats and stuff you can put on here as well. But from a legal hat, I would say, look, I think it's better that we disclose this, because you don't want to have your buyers come back on the day of settlement or, come back after settlement and seek compensation or terminate right up to the day of settlement to say, hey, you didn't disclose this, it isn't right, we're terminating, we're going to claim compensation. So that's not only does that put obviously your seller in a bad position, because then they've obviously got to try and remarket the entire property, which can cause devaluation and that sort of thing, purely because you don't know how the market's, if it was a 60-day settlement or something like that, another 60 days, they could be getting $100,000 less or something like that. I always run by, if you know about it, safer to disclose it than not to. Okay. So that's how it sort of goes. With when I say non-disclosure, misrepresentation and that sort of thing, it does give the buyer termination rights up to and including at settlement, so they can actually turn up to settlement and say, actually, we found non-disclosure, we're terminating this contract for breach. Then they have rights to go back and sue the sellers afterwards to claim any damages or anything like that. Okay.
Let's say I am selling the property for my brother-in-law, and the buyers come through, and do I have to disclose that they're a potential family member?
So because it's you're selling it for your brother-in-law, you don't have to disclose that. So a Form 7 comes into, an REIQ Form 7, which is a disclosure of interest, comes in when you are buying your own listing. So that's when you need to disclose it. If you're selling your own listing, I would always be upfront with the buyer and just say, look, this is my property. I can't give you any sort of recommendations when it comes to getting your own information and that sort of thing. However, obviously we're going to negotiate anyway, and it's going to be fairly clear.
I'd highly suggest you pay me a big number.
Exactly. I'm not going to let it go for under market value. So.
That's it. What about on the other side then? So say I've got the listing and my brother-in-law, he's like, I want this house, Josh, like help me get it. Like, what do I do then?
I would definitely be approaching your sellers and having that conversation with them directly. I know that it depends on what the procedures are in your direct office. So I know, like in that case where, especially if an employee comes and says, hey, I want to buy one of our listings and that sort of thing, the principal will generally look at the situation and say, look, we'll still sell it, but usually they discount the commission to null or something like that. So there's no future claims that they could have been, can't think of a better word of it, but ripped off essentially.
Yeah.
And then that way get them to sign something legal to say, we understand that this employee is buying it, they're an employee of the company, or they're a sibling, or they're related. We've discussed this in full. So basically always getting it right, written instructions and signing it is always safest.
All right, cool. Nice. That was a fun little game, eh?
It was. Scratching up on the real estate side.
Absolutely. So, like how can conveyancers really link up with agents and help them? Like why as an agent should I be contacting you more?
Yeah, definitely. I think honestly, if you're ever unsure about anything, or to just try and protect your hard work as well. So I think there's so many situations that we can't explain, or, that haven't arisen or that sort of thing right this second. And by having a conveyancer or someone that you can talk to that's got that legal background, they may have seen that it's situational. They know where to research or get that information. Conveyancers and law firms also have access to free advice. So we actually can contact really high solicitors that specialize in property law and everything like that. They can talk about ethics. They can talk about all the different situations and how to interpret it. So if we're not sure of a situation or we haven't seen it, we've got that, opportunity to go and speak to those people. And that's a free charge as well. So obviously there's no back charges to you guys or anything. It's that we can actually help you. The other side of it is like a lot of us are quite nerdy when it comes to legislation. So I actually, if I find a question that I don't actually know the answer to, I think I had one last week. I actually spent 4 hours just reading legislation, and I was like, can I interpret it this way and this way and this way? Bounced it off those ethical solicitors, and it turned out they're like, yeah, you've got a case. So we were able to, that was actually an agent whether the Form 6 was void or not due to backdating. So we were able to help them out and actually get a case for them.
This podcast show is all about you, agents. It's all about giving you the tips, the tricks, the strategies to take your business and your life to the next level. I'm very passionate about helping real estate agents, and the more people that subscribe and like this show, the better guests we can get on and the more value we can bring to you. So follow us, give us a like, and tell your friends. Look forward to working with you.
Yeah, there's a lot of agents who, they're so brand new, and like all really agents want to learn how to do is like get listings or market themselves. Like
100%.
They don't see the value in that side of the business. But like literally, like if you're new, sometimes the reason why someone wouldn't list their home with you is because you're not educated enough. Mm-hmm. So linking up with people like yourself and understanding contract law, like it's going to position you better.
Exactly. So I actually came from a background where I did 10 years in contract admin for a real estate company, and I saw so many things in the background. It was all of those newer agents coming through that weren't sure, or they'd make one silly error, they'd lose their commission and that sort of thing, and I actually really felt for them. So when I moved into the legal field, that's when I sort of started. I've got a weekly brochure that I send out, which is weekly fun facts, and it's about legislation for agents to help them grow and just what tips to help them learn, but also, make sure they're not getting themselves into that situation. And that's sort of where I actually started that from, was purely because I wanted to stop people losing, thousands of dollars or having their commission claimed, because like as a person, I felt awful. I've sold properties before in my previous life. I would have been devastated if someone took my commission off me because I forgot to tick a box or something like that. And that's what I really wanted to prevent happening in the future.
Yep, absolutely. I had this one once when I was, it was years and years ago. It was a big sale in Wellington Point. And went unconditional. The deal all went through, and I marketed the sale. So I marketed it as record sale because it was huge. This sale was a long time ago. And the buyer just like he put down like a $75,000 deposit, and he just got nervous.
Yeah.
And he like walked away from the deal and left, and just let the seller keep his $75,000 deposit. And I was just like, I couldn't even fathom that had happened. And I lost out. I didn't hit the seller up for the commission or anything, because I was like, I'm not going to hit him up for the commission. I haven't sold the property officially, it hasn't settled, so it can happen.
Oh, it definitely can. And I think I started in real estate when I was 17. So I just started doing the receptionist, and I think there was a lot of information where it was like, you sit down at the desk, start doing contracts, and you don't really understand at that age about all the things that could go wrong. And I think it was a good 6 months before I found out that there was a community title scheme contract. Like nobody picked up on it in the office. And then you look back and you're like, oh no, like they obviously all went through, but how many mistakes have I made as being that person just because I didn't have that person I could ask, or I wasn't getting that constant information, and I was too young to do the real estate course at the time. So I didn't have that option to go and do that.
Yeah, nice. When your clients, let's talk about the buying side to start with. So what's, the agent passes you across the deal. What are the common questions that the buyers are asking you?
The most common questions is, firstly, we do get a lot of reviews at the moment. So everyone's a little bit shaky when it comes to obviously signing on the dotted line. That's what we're finding. But they're wanting to know about termites, building, and, that sort of thing. So they're really wanting to make sure that they can get out under building and pest. And because there has been a lot of unreasonable requests, which have ended up in QCAT, not with our office, but in other ones as well. So what their rights are in regards to that, obviously cooling off. And a lot of people are coming through with special conditions, which are actually not special conditions because they're actually all standard terms of the contract, but they're really shaky about purchasing and that sort of thing. So they want you to sort of write it up to reiterate it in the conditions.
Absolutely. Yeah. And what about the sellers? Like we do the deal as the contract comes in, you're chatting to them as their conveyancer. Like, where are they nervous? Like, what kind of things are they asking you?
They're not really getting nervous until after it's sort of unconditional, and they're like, is it definitely locked in? Is it 100% settling on this day? And with REIQ contracts, you've got 6.2, so you've got 5 business days if a finance company isn't ready and that sort of thing. So there's a lot of concern around the actual settlement dates and what day it's definitely locked in, what happens if it's extended and everything like that. So that's probably, the sellers aren't too nervous until after it's really unconditional, or if they haven't heard by about midday on building and pest and finance condition due dates. So that's when you're sort of getting a couple of phone calls and you're like, look, they've got till 5, we'll let you know, and sort of explaining what happens. Just because it doesn't satisfy at 5, there's still options to negotiate, there's still options. It's not done until it's terminated, kind of thing.
Yeah. If your buyer came to you and they did the building and pest, for instance, and they're like, oh, listen, like, it's all good, but like I'm just going to try and get 20 grand off, so because I imagine a lot of them would probably do this, and so you have to do what your clients say. So you write up this request that you're unhappy with the building and pest because of X, like, does that happen often? Is that...
We do get requests they don't usually say, I'm happy with it and I want this. Usually they word it that, hey, I want a reduction of, for example, $20,000. So under the building and pest, it usually has to be something structural, severely damaging to the property. So that's when we just obviously draw their attention back to that part in the contract and say, look, with building and pest, it does have to be structural damage that usually is how you can get out of it. A doorknob being loose or it being the wrong color doesn't really substantiate to a $20,000 deduction. Yeah. So the biggest thing is they do have to act reasonable. So where act reasonable comes in is it is a very grey line. So if it was to being taken further for damages or end up in court, are they going to be seen to be acting reasonable if they're asking for a $20,000 reduction because there's a light bulb missing or something like that? So we do advise our clients that they must act reasonable at all times. Yeah. And by asking this, it could be seen for that if it is taken to court.
Yeah. In the conveyancing world, do you, like between you, do you like think like, oh, that conveyancer's a nightmare to deal with because like they're just so crazy, like they just never negotiate, like they're just coming in unreasonable all the time? Is there a stigma like that in the conveyancing world with each other?
I don't think there's a stigma of such. I think there's a lot of conveyancers that we work together a fair bit, so we all know how each other acts and everything like that. There's definitely, we get into some heated conversations when it comes to different conveyancers, and you'll be going back and forth and fighting for your interpretation and your legal rights because you're always acting in the best interest of your clients. However, we make a rule in our office because sometimes when we are acting on both sides as well, you can't take it personal. And basically, it's a little bit of competition nearly, who gets the last say.
Yeah.
And it's never personal, but it's always a learning experience. When another solicitor does something or interprets it that way, it's a really good opportunity for you to look inside your policies and procedures in your office and say, okay, well, let's save that for that if that case comes up another time, or if an agent has that question in the future, we've got this ready to go. So I don't think it's a thing where you have the stigma of saying, oh, that person's not very good. I look at it more as inexperience. They haven't had that opportunity before and that sort of thing. So as much as it sounds like you're hammering them on from the other side, but you're probably upskilling them at the same time because they're going to remember this as, that deal that went bad for them or something like that. And they're going to be like, look, it was an awful time for me to try and learn this, but it's actually upskilling them at the same time.
Yeah. And at the end of the day, like, if those same dramas come at you, you have to basically submit and be like, well, yep, that's fair. It's because that's what we did in the last deal.
Exactly. And, every office will handle situations slightly different. So it's really good when you do have those situations come up to see how they handle it, because sometimes you can improve your situations just that little bit. And when it does come for you, the next time you can go, okay, I'm going to do it this way. And then, you've immediately upskilled, so your clients are getting a better service as well.
See, we don't quite do it like that in the sales world, like it's no negotiation. When I'm dealing with another agent or something, I'm like, well, listen, if you want to be a part of this deal, then you're going to need to come to my level because I work for my sellers. You're the buyer's agent. Come up.
Yeah, it's very different.
That's what I like to do. So it obviously finding that happy ground in the conveyancing world is important.
And I think that's where this conveyancers are really trying to work together. We've got one client. We don't speak to the other side when if we're acting for the sellers, we can't legally speak to the buyers or anything like that. So I think it's good because then there's no emotions because we're not emotionally attached to the sale as well. So for example, it's not our commission on the line or anything like that. So we can purely just fight for our client. They can purely just fight for their client. And that's where you get that medium ground.
And it's all via email, isn't it?
Yes, everything has to be in writing. So
yeah, definitely. Yeah, I'm always just like, the solicitors just never ring each other, like they could probably solve this problem, but it all does have to be in writing, doesn't it?
It does, and there's very strict information when it is, when you are taking phone calls from the other side, even if you are talking to them, because sometimes there is phone calls going back and forth. You have to say off record if you want to have a conversation without it being recorded, because then we have to obviously record it in line and keep notes, because if it did go to court, we have to be able to produce all of this down the future, and that could happen in 5 years' time, and you have to be able to remember every conversation.
Yeah, definitely. Yeah, I'd be a nightmare at that. So what mistakes, you said about the beneficial interest and all that sort of stuff, but with the actual contracts themselves, like the agents still handwriting them, or are they doing it more professionally these days?
50, to be honest.
Really?
So we do a lot of work out west. So we do it out in Tara and that sort of thing. So a lot of those ones are handwritten. The ones closer to the cities are always docu-signed.
Yeah.
So it does depend on where you're coming from and that sort of thing to whether they're handwritten or not.
Can be a bit of a dog's breakfast, those handwritten ones, eh?
Yeah, but even though they're typed, it doesn't mean that necessarily all the information's correct. One easy one that's been really forgotten is people don't know if it's smoke alarms are compliant or not, so they're just leaving it blank. So leaving it blank is still non-disclosure because you're not disclosing it.
Yep.
And it's always better to say that they're not smoke compliant and then get your seller to provide a smoke alarm compliance certificate prior to settlement, and then they won't be charged that 0.15% of the purchase price.
Yeah. Do you like how the whole contract process is done in Queensland, or would you just rather the buyer, when they find the property, just come to you direct, you do the contract and then give it to the agent?
It's a tricky one. So obviously there's a lot of states that do it different ways. I think it's really good when you do have some really good agents that are negotiating every step of the way. I definitely think I think nearly there should be a rule that, you can't do your own contracts until you've done 5 years in the, industry, or you've sold a certain amount of properties or something like that. You have to go to the solicitors. I definitely think that would be a great rule.
Yep.
Unfortunately, I don't think Queensland Law Society are planning on bringing that in any day soon. But I definitely think you can see where the experience comes in, and definitely like that. There's some really great agents out there, like, we deal with you obviously a lot, and we don't get errors from you because you know what you're talking about and that sort of thing. But I think it's also an opportunity when we do see these errors. I get to pick up the phone to the newer agents and be like, hey, look, I just want to help you for the future. Don't do this again.
Yeah. Where'd you get that clause from, bro?
Let's never use that again. Usually they go, I wrote that. I think this was really
we know.
good.
Yeah, we know you did. Yeah. Absolutely. I think, definitely agents, you need to get a conveyancer that you trust, and you need to, pick their brain. You need to get them into your office. You need to, make yourself known to these people, because you can learn so much. And I think people have learned a lot today from you coming in.
Thank you. Hopefully it's provided some value, and thank you so much for having me.
Absolutely. Thank you. It was awesome.
Have a good day.